Case of the People versus South.
Mr. Plug, Doppy, leave before Ms. South is approaching from my right. Ms. South, can you state your name?
Myra South.
What the court has decided to do, given the responses.
Your Honor, could we approach for a moment?
I don't know that there's anything you can say that's gonna let
Not yet.
approach.
I may approach. Thank you.
Fact, we had a bench conference in this case, and given the responses from the defendant, the court is going to choose on its own. Understanding that counsel has given me an explanation that I'm not going to take the defendant's plea today. I will adjourn the probable cause conference to my next available date, which will be September.
Right here, we see the judge refusing to take the plea and pushing the case to a later date. Notice how the bond remains unchanged. This signals the court isn't ready to shift trust toward the defendant until more clarity comes in. What do you think? Should courts hold off until discovery is fully settled, or is this dragging the process too long?
25th, 2025, 90. Or right, her bond will continue. Thank you.
Thank you, Your Honor. Yeah.
Court does call the case, People versus Jordan McKinney.
I always end on behalf of people.
David I. Goldstein appearing on behalf of the defendant.
Her name?
Jordan McKinney.
Thank you.
Your Honor, we have requested an adjournment in this matter. I still have not received a discovery from the people. I did discuss it. And I know it's coming, but we have not received it yet.
All right.
So I'm asking for a 1-week adjournment, if that's okay with the court.
1 week. Is the discovery on its way, or?
Yes, Your Honor, it should be.
Okay.
I believe it was sent to previous counsel and then it's making its way.
Gotcha. All right. Probable cause conference will be adjourned September 18th, 2025, 9 a.m.
I would like to address the court on the issue of bond, and I did indicate that I was going to. Your Honor, just very, very briefly, I understand that the bond in this case is $35,000 cash or surety. I understand the charges against my client. My client does not have any other pending cases. He is not on probation or parole. If he were allowed to post bond in this matter, he would be living in Westland with his mother. The complainant in this matter, I assume, lives in Washtenaw County because it's a city of Ann Arbor case. The court can deal with the issue of protection of the complainant with the conditions and a GPS tether. But given the lack of any significant criminal history, I couldn't find anything in Washtenaw County. There was something that might have happened in Ohio when he was in school approximately 10 years ago, but I can't find anything in this county more recent than that. So I'm asking for a reduction, Your Honor.
Your Honor, at this point, I would be objecting. The facts of this case are that the defendant was driving with the victim and her children, and the victim was becoming uncomfortable and wanted to leave with the children and take a bus rather than be with the defendant. He would not let her out of the car and continued speeding down the road. While he was driving, he punched her in the face.
This is where things get intense. The defense tries painting McKinney as a low-risk man with no recent criminal history, but the prosecution drops a bombshell, an alleged violent attack with kids in the car. If true, that paints a picture of someone reckless and dangerous. Audience, what's your take? Should prior clean records outweigh the severity of fresh allegations?
With a closed fist and wouldn't let her or the children get out of the car. They eventually approached an Olga's and she tried to get out. There was videos of her from bystanders showing her trying to leave the vehicle, and he would speed forward. Eventually, she was pushed from the vehicle by him, and her older child was able to get out of the car. The victim then tried to get the younger child, an infant, from the car, but was unable to after he sped off with the infant child's door still open on the vehicle. So at this point, I would be objecting to any modification of bond at this point, given the facts of this case.
Well, Your Honor, there are no facts of the case. There are allegations, which have not yet been even to a standard of probable cause been proven. So I would indicate, just based on the charges and my client's lack of any significant criminal history, that 35,000 is not reasonable.
Well, given the circumstances as at least explained, and certainly maybe at some point there'll be a different version of that, but given those circumstances, the court would consider a defendant a risk to the public and would deny the motion for bond reduction. Court finds that bond is appropriately set.
Thank you, Your Honor. As soon as I get the police report,
So it's bond.
hopefully this week.
Thank you. Court calls case of the People versus Adrian Braswell.
Trevor, may I vote for the people?
And there it is. The judge locks in the bond at $35,000. This moment shows how allegations, even unproven, can heavily influence bond rulings when public safety is at stake. Judges walk a fine line here, protecting victims and communities, while not jumping ahead of due process. Was this the right call or too harsh before trial?
Good morning, Your Honor. Chris Seastope on behalf of Adrian Braswell, who should be appearing via Zoom. Now.
Individual who's iPhone 1.
That's me.
That's him.
Yes.
Your name, sir?
Adrian Braswell.
Your Honor, here and I approach really quick. Oh, I promise it will be quick.
Okay.
Thank you.
All right, record should reflect the bench conference in this case. I will adjourn the probable cause conference in this case to October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Mr. Braswell, I'll be in touch with you soon.
All right, thank you, Mr. Braswell. Court does call the case of the People versus Dwayne Stevenson.
Emily's on behalf of the people.
David I. Goldstein appearing on behalf of the defendant. Mr. Stevenson, state your name, please.
Dwayne Stevenson.
You're on the same situation in this case. The discovery in this matter is bouncing around about 3 different attorneys because the public defender was appointed. They had a conflict out. Then Mr. Drukas was appointed. Somewhere in the blogosphere, the discovery is coming. I believe that I received his about 2 minutes ago, but I haven't had a chance to check.
So this defendant?
This defendant, not Mr. McKinney, this defendant.
Gotcha. Okay, so you want an adjournment?
Yeah, again, 1 week, Your Honor. And I do want to address bond in a moment when the court's ready.
You can be part of 150 cases. September 18th, 2025, 9 a.m.
I'm used to that, Judge, you know. Judge, just on its face, my client's bond is $500,000. I think on its face, I mean, that's a bond you usually get in a murder case, or I mean, not a murder, but an assault with intent to commit murder, a CSC1, an armed robbery, something of that nature. My client is not on paper of any kind. I do acknowledge that he does have a prior criminal history, but his most serious charge was 2008, I believe it was, which is 17 years ago. He came out of prison on that in 2015. He successfully completed his parole. He's had one minor brush with the law since that time, and he would be living with his mother in Ann Arbor. And again, the court can set conditions, including GPS tether, that would protect the public and the complainant in this matter.
Your Honor, I would object to any modification of bond. I believe in this case, I originally requested a bond of $1 million, and we were given the $500,000 cash surety. Mr. Stevenson has a previous history of 28, few cases prior to 2016 OWI, 2018 attempt RNO, 2018 pre-attempt RNOs, 21 receiving concealed under 200, 2020 dismissed GBH and DB, 24 RNO, and a 24 DB conviction. I expect that this does go to exam. It could potentially, an AWIP could be added, as well as he could be made a habitual fourth violent offender. In this case, the victim reported 3 different distinct assaults in which they involved Mr. Stevenson punching her multiple times, kicking her, strangling her to the point of unconsciousness. The victim went to see her mother. Her mother observed her to be limping with broken teeth, laceration to her lip. She went to the doctors and found that she also had a broken rib. The assaults kind of follow the same pattern of strangling, punching, kicking, dragging her up the stairs by her hair, fracturing her rib, punching her so hard in her ear she has hearing loss. He also sent her texts that say things like, "I wish you would have died when I put my hands on you for real. I wish you would have just died on the floor and I would have kicked you. Y'all played with my time. I should have killed both of y'all. Answer the effing phone. You don't know where my shit at. Open the door or I will shoot." And on a voicemail that I listened to, given to us by the victim from the defendant, he says, "I know you called the police, so I will kill you before you get any chance." I mean, I have concerns for not only for safety, but the fact that he has this violent criminal history of RNOs as well, that he's a danger to the community, and then he could and maybe will kill her if he is let out. I have great concerns for her safety. And I believe that a $500,000 cash surety bond is appropriate, even though we did request a $1 million bond, given the facts of this case and the allegations.
Well, again, Your Honor, she did say allegations, and that part
Now buckle up. This one is chilling. The prosecution unloads a mountain of disturbing details: strangulation, broken ribs, violent texts wishing death on the victim, and even threats to kill if police were involved. These aren't just accusations. They're paired with medical evidence and digital messages. If even half of this holds up in trial, Stevenson is facing some very serious time. Could any judge realistically reduce bond after hearing this?
I can accept. They are not facts. They're not facts until they're proven. And, you know, Your Honor, I'm not going to justify my client's prior history, except to say with regard to those RNOs that have occurred since he was out of custody and out of parole, he doesn't like police, but she's not a police officer. So.
And Your Honor, I did want to put, he was in prison in 2009 for armed robbery, home invasion 1.
Right. That's what I said. Right.
Given all that, the court does consider the defendant to be a danger to the community. I don't believe that he's necessarily a risk of flight, but certainly a danger to the community, especially if the allegations are true regarding the shooting and or killing of an individual after these circumstances. The court would therefore deny the defendant's request for a bond reduction. Bond would remain the same.
I'll be here this weekend once I get the discovery. Okay.
Thank you. Court calls case People versus Adam Allen.
Good afternoon, Your Honor. Raymond Cook for the people.
Deborah Schlossel on behalf of the defendant, Mr. Allen. Your Honor, I don't know what happened to my client. He texted me this morning. I thought he was going to be here. I just called him.
So he's a no-show like his drug test. I mean, I'm sorry. Go ahead.
Well, he tried to rectify that, I believe, this morning or yesterday. I thought maybe he got arrested by the court. Is it possible that he might be
It's
somewhere?
possible. Did we? Oh, where's he?
I'm right here.
Oh, did we issue a warrant? Yes, I think we did. Well, no, I got a recall.
We issued an order to comply just last week on Friday.
Right.
So no warrant.
No warrant as of yet.
So, Your Honor, he told me that he went in to get everything resolved either yesterday or today, and he texted me. I told him that the hearing today was at 3 and not 9 a.m., which, people get the notice that says that. He said, okay, he was planning to be here. I don't know what happened. I called him, I've texted him, and he's not here. I have not received a response. Your Honor, I think something probably is wrong. I know you're not going to grant this, but I have to ask anyway. I would ask that either I be allowed to waive my client's presence or that this matter be adjourned out a week or two so that my client would have a chance to show up.
Bench warrant will issue for defendant's failure to appear. Bond will be set to $25,000 cash surety. That warrant will issue immediately. And certainly you can do a warrant recall if he has justification for not appearing.
And here's a courtroom classic: failure to appear. The defense tries to spin it, but the judge isn't buying excuses. A $25,000 bench warrant gets slapped down immediately. Judges don't play around with absences. It's not just about missing court. It signals unreliability and risk of flight. Viewers, if you were the judge, would you issue a warrant right away or give Allen another shot to explain himself?
Thank you, Your Honor.
Thank you. Court does call the case of People versus Raul Fernando.
Good afternoon, Judge. Good to see you. I dispatch on behalf of Mr. Raul Fernando, who is presently at Zoom. Judge, thank you for allowing my client to appear via Zoom.
Sir, can you state your name?
Raul Fernando.
Thank you, Judge. Today is the day and time set for our PCC. I am respectfully requesting a 2-week adjournment if at all possible. I did receive and review the written discovery. I did receive this week video discovery. This week was a bit hectic. I just needed a little bit more time to review everything and sit down with my client and review it as well, Judge. So I'm just respectfully requesting.
I appreciate the candor.
It's usually I'm very good at just
Yeah.
downloading can take sometimes hours depending on the Wi-Fi, and it's just been a little bit hectic the last 2 days, Judge. So I respectfully need the time.
I understood. So
Thank you.
without objection, I will adjourn this to September 25th, 2025, 9 a.m.
Thank you, Judge. Thank you so much for your time. Have a wonderful day.
You do the same. Court calls the case of the People versus Joseph Spittler.
Good afternoon, Judge Lawrence H. Margolis with and on behalf of Mr. Spittler, who is present with me via Zoom. Mr. Spittler, please state your name.
Joseph Spittler.
Thank you. All right, what are we doing?
Judge, today's the date and time set for PCC. I've talked to Mr. Kennedy. He was going to ask for a little time. We're working on a resolution that requires the parties to seek more time. And Mr. Kennedy is not here, so I'm feeling okay that I can make it on his behalf, but I will defer to Ms. Londi as well.
Well, that's not her name, but go ahead.
Oh, I didn't hear. Sorry.
That's my understanding is we're looking for 2 to 3 weeks, Your Honor.
All right. Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Thank you, Judge. Have a good day.
Thank you. Court calls case People versus Justin Robinson.
Good afternoon, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Robinson.
Her name?
Justin Robinson.
Thank you. Where are the rest of your pants?
Your Honor, I was in the rest because I had to take the bus here. I don't have reliable transportation. I'm a 24/7 dad, so
I just wanted to make sure I got here. I
No,
apologize.
I got you. Just next time wear long pants, please.
Okay.
Go ahead.
Your Honor, respectfully requesting an exam date.
All right. Discovery is complete, counsel.
Yes.
And would the people have with their witnesses available on the 23rd?
Not available on the 23rd, Judge.
This would be easy. No, go ahead.
Sorry.
Then we would have the 30th.
I believe I'm available. Yes, I'm available.
All right. Any objection from the people to that date? Preliminary examination in person, September 30th, 2025, 9 a.m. before Judge Washington.
That's in this building, correct, Judge?
Oh, yes.
All right.
It all happens here. Bond will continue. Thank you.
Thank you. That's it for me.
Court calls the case. People versus Anthony Alfaro Callejas.
Jennifer, that was the people?
Good afternoon, Your Honor. Attorney Zach Bonham on behalf of the defendant who's joining me at the podium now. Good afternoon, Judge.
What are we doing?
So today, Your Honor, we'll be asking for an adjournment of the PCC. We have one piece of discovery that's outstanding that we need to have, and I believe we'll have that very shortly. The other thing, I'd like to address bond when we're done with that.
Well, there's supposed to be a hearing on this bond violation.
Correct. Well, this is also a PCC and a bond violation hearing.
I know, I said it.
For the bond violation, my client would be admitting responsibility to the bond violations. I believe a week would be sufficient, Your Honor.
Oh,
Okay.
We need more than a week. I checked it. There's a video that was taken by a witness that defense counsel was looking for. I checked. It's not something that we have. It appears that officers just looked at it and the phone that it's on briefly seen in the body cam. But it is not a criminal report that the police actually took it from that witness. I did email the listing OIC to get us that video. He said that he is no longer the OIC. He is for the request to new OIC. But we need more than a week because someone has to go out there and get that video.
Understood.
all right. Well, you think they'd be able to do that in 2 weeks' time? Or is it going to take longer? I mean, obviously there are things you can't know, like the person that has the phone, how cooperative they're going to be or anything else, but.
Your Honor, I mean, I think it should be able to be done in 2 weeks. I just don't know that it's likely to be done in 2 weeks.
All right. Here's what I'll do. Won't quite go 3 weeks. I'll set it for September 30th.
That's good, Your Honor.
All right. At 9, I'll set it at 9 at this time. All right. As to bond.
Your Honor, I spoke with the prosecutor about how to address bond in the situation. Before my client was incarcerated last week, he had been on home confinement. Speaking with the prosecutor's office, they would agree that home confinement would be appropriate for my client. However, we'd be asking for a scram tether rather than the sober link. As what brought us here for the bond violations is my client, in part, saying that he was testing inaccurately. He thought he was supposed to be doing one way, it was supposed to be another way. Let's take that out of the equation. Let's put him on a scram tether so we'll know right away whether there's a violation.
Take his lie out of the equation.
His
No, you don't need to respond.
Thank you. I
That's
appreciate that.
All right.
So we'd ask that he be back on the scram tab, well, go onto the scram tab rather than sober link. And if the court is willing to place him back on home confinement, prior to the last PCC, I submitted a proposed amended bond order. My client has a new apartment that he had just rented. We'd ask that home confinement be at the new apartment, along with the other conditions that we had, that he be allowed to leave the residence for work, medical appointments, a court hearing, limited exceptions. And I guess the last thing I would mention, that he still has his job at Los Amigos. He said he was making close to $6,000 a month working there, but because of the situation that he placed himself into, he still has a job available. It is with reduced hours, so he can still make roughly $2,000 a month, but the job is still there.
Here's what I'll do. On his bond violation, I'll sentence him to 7 days credit for the 7 days that he served. And then I will reinstate his previous bond with home confinement and a scram tether. Both of those must be fitted prior to his release.
And that's at the new address, Your Honor?
Yes, they will get an address from him, so he's got to make sure to have that address.
I'll make sure that he does. I just want to make sure that there'd at least be a record that it would be for his new apartment. So
Yes.
do you have the address?
Yes, I do, yeah.
Can you tell the judge what your address? New address?
Well, no, I don't want it on the record. He can give it to you.
Never mind, Your Honor. We don't need to do that.
All right. And we'll make sure that those orders are entered.
I also have a green sheet if the court would like it.
Yes.
Thank you.
All right, we're all set. Thank you.
Your Honor.
Thank you, Your Honor.
You need this.
Yeah, we just set it down.
Is that it for us? 14A stands adjourned.
What a docket. From denied bond reductions to jaw-dropping allegations of abuse to defendants fumbling with missed court dates, today's hearings showed just how unpredictable and emotional the justice system can be. Judges balance protecting the community with safeguarding due process, and every ruling carries weight. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns right here on Verdict Forge.